Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana, CCJ application number 1 of 2019 between Christopher Persaud versus Toolsie Persaud and Toolsie Persaud Limited. For judgment this afternoon. Can we have the appearances for the court, please? Thank you.
If you please, Timothy Jonas, in association with Sandy Ramirine, for the intended applicant.
May it please Your Honors, good afternoon. Robin Stovey with Stephen Fraser for the respondent.
Yes, thank you, Counsel, and good afternoon. The court arrived at a unanimous judgment in this matter, and the judgment was authored by Mr. Justice Burgess, and I will invite him to read a summary of it.
Thank you, Mr. President. I believe that I'm supposed to enter a caveat here, which is that this summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. Now to the summary. Christopher Persaud, acting as executor for David Persaud, sought special leave to appeal the decision of the Court of Appeal of Guyana regarding whether the appeal against the decision of Mr. Justice Persaud in the High Court should be to the Court of Appeal or the full court. The genesis of the substantive issue was an oppression action which was filed in the Commercial Division of the High Court under Section 224 of the Companies Act, Chapter 8901. In the High Court action, the applicant alleged that the respondents administered the business and affairs of the company in an oppressive manner. The applicant also alleged that the respondents exercised the powers of the directors to the unfair prejudice of the deceased. The deceased was a minority shareholder in Toolsie Persaud Limited, one of Guyana's largest companies with interests in hardware, quarrying, and timber, while Toolsie Persaud, the brother of the deceased, was the majority shareholder in the company. The applicant's application under Section 224 was lodged pursuant to Section 232 of Chapter 8901. That section provided for such an application to be made by originating motion. The application was heard by Persaud, Mr. Justice Persaud, in open court, where cross-examination of the witnesses took place. During the pendency of the proceedings, but prior to Mr. Justice Persaud giving his decision, new civil procedure rules were implemented, replacing the previous High Court rules. These new rules altered the manner in which oppression actions would be instituted under the Companies Act, rendering such decisions appealable to the Court of Appeal, as opposed to under the High Court rules, which made provisions for an appeal to the full court or to the Court of Appeal, depending on circumstances. Mr. Justice Persaud, in giving his decision, dismissed the application, and the applicant, being dissatisfied, was determined to appeal. In light of the new CPR rules, the applicant lodged his appeal before the Court of Appeal. The respondents strenuously opposed this application, arguing that the Court of Appeal did not have jurisdiction to hear an appeal from a decision of a judge in chambers in proceedings commenced by way of originating summons. In light of the respondents' objections, the applicant filed an application in the full court pursuant to Section 6 subsection 8 of the Court of Appeal Act, seeking a determination of whether the order of Mr. Justice Persaud was a final order of a judge of the High Court, not made in chambers or in summary proceedings, so as to fall within the appellate jurisdiction of the Court of Appeal. The applicant also sought in the application an extension of time within which to file and serve a notice of appeal to the full court, if it was determined that the appeal should be to the full court. Having been duly informed that there was an appeal before the Court of Appeal, the full court dismissed the application before it as an abusive process. The applicant then appealed this decision to the Court of Appeal on the basis that it was erroneous in law. The Court of Appeal now had before it two appeals, one in relation to the decision of Mr. Justice Persaud and an appeal of the decision of the full court dismissing the applicant's application. The applicant therefore sought two orders in the Court of Appeal. The first was an order that the proceedings before the Court of Appeal be heard together with the appeal of the full court's decision. The second was an order that the appeal against the decision of Mr. Justice Persaud be referred to the full court for hearing on such terms as the Court of Appeal deemed just, if it was determined by the Court of Appeal that that appeal falls properly to be heard by the full court. In the Court of Appeal on the 11th of January 2019, after hearing the two appeals, made an order dismissing the appeal of the full court's decision on the basis that the appeal from the full court was void as being filed without leave in contravention of Section 6, subsection 4 of the Court of Appeal Act. Secondly, the court granted the order sought by the respondents in its jurisdictional objection and dismissed the substantive appeal on the basis that the proceedings at first instance were proceedings before judging chambers, were not affected by the new CPR and did not change their character so as to be appealable to the Court of Appeal. It is these decisions which form the basis of the appeal before this court, which raise the knotty procedural questions now before us. This court first embarked upon a consideration of the preliminary issue raised by the respondents that the CCJ did not have jurisdiction to hear the underlying appeal. The court reiterated the principle that in exercising its discretion upon an application for special leave made directly under Section 8 of the CCJ Act, the applicant must show that the appeal has a real prospect of success. This court stated that the preliminary objection failed, since this case was a case in which the court would consider that the interests of justice required the exercise of the discretion to waive any procedural irregularity and therefore granted special leave to appeal. This court then went on to consider the application for special leave as the appeal. In this court's assessment of the first issue in the appeal as to whether leave was required for the appeal from the full court's decision to the Court of Appeal, the court was of the view that the decision of Mr. Justice Persaud was appealable to the Court of Appeal. It was noted that the express language of Section 6 of Section 4 clearly indicates that it applies to, quote unquote, a decision of the full court upon appeal from a judge of the High Court. This decision of the full court against which the appeal was made, in this case, was a decision of the full court on an application made by the applicant to the full court. There was therefore no appeal to the full court from a decision of a judge of the High Court. Section 6, subsection 4 was therefore not applicable, and as such, leave to appeal was not required. This court, in approaching the question of proper forum of appeal, noted the fact that the oppression application made pursuant to Section 224 was governed by the provisions outlined in Section 232 of the Companies Act. Such an application is by way of originating motion to a judge in open court, notwithstanding that as a matter of form, it is constrained to be made by originating summons. This court noted that the reasoning and the conclusion of the Court of Appeal were doubtlessly predicated on the erroneous premise that the applicant's complainant oppression application by originating summons before Mr. Justice Persaud was made pursuant to the rules of the High Court. However, it was not. It was made pursuant to Section 232 of Chapter 8901, which expressly provided for an application by originating motion, which, by Order 41, Rule 5.3, shall be made by originating summons. It therefore followed that an application by originating summons made under Section 232 could not be ipso jure an application to a judge in chambers, as the Court of Appeal held. It also noted that the written and oral submissions by counsel before this court were similarly based on the erroneous assumption that the applicable rules were either the old rules of the High Court or the new CPR. As such, the fact that the applicant's application before the High Court was expressly made under Section 232 of Chapter 8901 was determinative of the question whether the appeal from the decision of Mr. Justice Persaud was to the full court or to the Court of Appeal. Such an application was by originating motion to a judge in open court, notwithstanding it being made by originating summons. Indeed, this case was conducted in open court, where witnesses were cross-examined on the affidavits filed, and accordingly, the proceedings before Mr. Justice Persaud was not in chambers. The Court of Appeal therefore erred in holding that the appellant's appeal from the decision of Mr. Justice Persaud in those proceedings was to the full court and not to the Court of Appeal. This court reiterated that Parliament introduced into Guyana the complainant oppression remedy in Section 224 of Chapter 8901. This remedy is generally regarded as a broad, flexible, equitable tool given to the courts to deal with complainant oppression in companies, and that it is not to be defeated by technicalities. It is this remedy which the applicant sought, and having been unsuccessful, thereafter did all that a diligent litigant ought to have done to secure his appeal. Notwithstanding this, the unfortunate result was that the applicant ended up being caught in a web of procedural technicalities which frustrated his substantive appeal. This court stated that despite the confusion which arose with the promulgation of CPR, the Court of Appeal had an inherent power to rectify matters where there has been a procedural error to ensure cases are dealt with justly. Unfortunately, neither the full court nor the Court of Appeal availed itself of this power. This court therefore felt duty-bound to exercise its inherent power to ensure that unnecessary disputes over procedural matters are discouraged in order to uphold the overriding objective to deal with cases fairly and expeditiously so as to produce a just result. In these circumstances, this court granted the applicant special leave to appeal and treated the hearing as the hearing of the appeal. In the following appeal, in allowing the appeal, the court ordered, 1, that the decisions and orders of the Court of Appeal made on the 11th of January 2019 be set aside. 2, that the Court of Appeal was directed to hear the appeal in relation to Mr. Justice Persaud's decision. And 3, that the appellant's cost of the application be paid by the respondents to be taxed if not agreed. Thank you, Mr. President.
Yes. Those are the orders of the court. If the parties have not yet received copies of the judgment, they will do so very shortly. And Justice Eaton, who is absent, nevertheless has concurred in this judgment and has signed the judgment as well.
2 million.
Rise.
2 million. Very good.